Major breaking news. A huge oral argument just took place in the United States Court of Appeals for the Ninth Circuit in California. In the case of Sanchez versus Bonta, the question is whether or not California's outright ban on suppressors and silencers is constitutional under the Second Amendment. A 2-1 decision may very well be coming forth in favor of the Second Amendment, but one never knows for sure. We're going to break it down when we come right back with our fingers crossed and our candles lit. Hey folks, I'm Mark Smith, host of the Four Box Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, folks, so we just had a huge oral argument in the United States District Court for the Ninth Circuit, generally a bad court for the Second Amendment, as you well know. Nevertheless, the three judges that heard this argument, two of whom seemed sympathetic to the arguments being advanced by the Second Amendment rights claimants who were arguing that California's state ban on suppressors and silencers is unconstitutional under the Second Amendment and Supreme Court precedent. Now, I should note one thing before we break down and analyze this case. Much of the discussion during the oral argument was involving a Ninth Circuit Court of Appeals precedent called Duncan versus Bonta and some related Ninth Circuit precedent that, in my view, is entirely inconsistent with the text of the Second Amendment and Supreme Court precedent. But until the United States Supreme Court steps up and spanks the Ninth Circuit out there in California, the absurd precedents set forth by the Ninth Circuit in favor of the government against liberty and against the Second Amendment, they're going to stand out there. The reason why that is significant is that the lawyers arguing in favor of Mr. Sanchez, who originally brought this lawsuit pro se to challenge California's suppressor ban, the lawyers arguing in favor of the Second Amendment really had to kind of parallel path the arguments. They had to argue in the alternative. On the one hand, of course, they were arguing in favor of the Second Amendment, arguing that you cannot ban suppressors under the Second Amendment based on United States Supreme Court precedent, which, of course, is the definition of arms as to anything that can be used offensively or defensively, and the in common use and the dangerous and unusual standard that was set forth by the Supreme Court in Heller, where the government bears the burden to show that an arm they ban or otherwise regulate is dangerous and unusual and thus not in common use, for example. And at the same time, the lawyers for the Second Amendment were also basically trying to show that even under the wrongly decided standard of Duncan versus Bonta, which made it easier for the government to win, of course, even under that standard, the Second Amendment should prevail and that suppressors cannot be banned even under the Ninth Circuit's favorable to the government standards for Second Amendment cases. Well, as you know, to understand whether or not suppressors are protected under the Second Amendment, whether it be under Duncan versus Bonta, Ninth Circuit precedent, or the Supreme Court precedent, the first question is, are suppressors arms? Well, the answer is, for several reasons, yes. But more specifically, let me be very clear about this. Suppressors are indeed arms, and we're going to explain why in a second. But in many respects, it actually doesn't matter whether or not suppressors are arms. Now, here you may say, Mark, what are you talking about? Well, because the Supreme Court has pointed out in the Rahimi case that the Second Amendment's plain text, the right of the people to keep and bear arms, shall not be infringed, covers not just arms, but arms-bearing conduct, meaning anything that influences or impacts upon gun owners would obviously be a regulation of or impacting arms-bearing conduct. But before we get too geeky on this, I just want to step back for a moment and let you understand the two arguments being advanced by the various sides. Let's start off with California's argument as to why they are totally cool and totally good with and totally legal by banning suppressors and silencers under their state law. And that all is consistent with the Second Amendment according to California. Here's what they had to say. California has prohibited the possession of firearm silencers for nearly a century. These devices attach to a firearm and are designed to silence, diminish, or muffle the sound associated with discharge of the weapon. Given their inherent design and function, silencers render it more difficult for potential victims to detect and flee from a shooting and for law enforcement to locate and neutralize a shooter. Because they are particularly dangerous firearms accessories that exacerbate the lethality of firearms and lack a counterbalancing self-defense use or utility, silencers have been heavily regulated since the early 1990s. Here, plaintiff and appellant Gary Sanchez filed a pro se complaint in district court challenging the constitutionality of California's prohibition on silencers. Mr. Sanchez argued that the devices are protected by the Second Amendment and that California's prohibition is contrary to the nation's history and tradition of permissible firearms regulation. The district court rejected plaintiff's claim and dismissed the complaint without leave to amend. So that's what California has to say. Do you hear what I just said? Their argument as to why suppressors are dangerous and unusual weapons and can be banned is supposedly because if some nutjob, wackadoodle, took an arm with a suppressor and started firing it off, it'd be harder for people to figure out whether or not there's gunfire, and it'd be harder for the cops to find out where the guy was. Again, focusing on the misuse of an arm, which the Supreme Court says we focus on the lawful uses of an arm and not the misuses of an arm, because again, anything on the planet can be misused and abused by nutjob, wackadoodle psychopaths, terrorist cartel members, and the like. The Supreme Court understands this. This goes all the way back to even before our founding fathers, where Cesare Beccaria, the Italian Enlightenment criminologist, who specifically says that, arms ban laws only help the criminal and hurt the victim. I'm happy to report that I think in part Mark Smith and the Four Boxer Diner brought Cesare Beccaria back into the limelight in the 21st century, because you now see Cesare Beccaria talked about quite extensively in legal briefs involving the Second Amendment. So I'm happy to have contributed in a small way to bringing his views back to the fore, because again, his views were the founder's views, because he was very popular with the founding fathers who wrote the Constitution. Now, with that said, of course, here's what Mr. Sanchez's lawyers had to say, pointing out why, in their view, the California position is simply wrong and inconsistent with the Second Amendment. Here's what they had to say. Firearm suppressors, which reduce but do not eliminate the noise emitted from a firearm, support the safe and effective use of a firearm and are commonly used for lawful purposes in the United States. They are legal to possess in the vast majority of states, and millions are possessed by law-abiding Americans for lawful purposes, including to prevent irreversible hearing damage from firearm use in training, in self-defense, and in hunting. Indeed, the federal government has described suppressors as the only truly effective means of preventing hearing damage while using a firearm. The hearing protection of a firearm outfitted with a suppressor serves critical self-defense functions, ensuring that an individual defending self, family, and home can prevent the temporary deafness or disorientation caused by a firearm blast. This allows an individual exercising the constitutional right to self-defense to hear an intruder and communicate effectively with family members and the authorities. Suppressors also facilitate training with firearms by reducing the sound of firearms and therefore protecting the hearing of everyone in a training facility. Even still, California has enacted a flat prohibition on the possession of these commonly used and safe instruments, even when they are properly registered and taxed under the Federal National Firearms Act, a process that requires a thorough background check. So that's how the parties laid it all out. So as you know, under the Bruin methodology, which is really the Heller methodology in a paint-by-numbers fashion, you start with the plain text of the Second Amendment. The right of the people to keep and bear arms shall not be infringed. And the question is whether or not has the government impacted or regulated in some way something that falls within the text of the Second Amendment. The answer is undeniably yes here. In fact, the brief in favor of Mr. Sanchez sounds very, very similar to some of the arguments that I've made at Gun Owners of America events, Second Amendment Foundation events, and on this YouTube channel. Check it out. As the Supreme Court has explained, an arm includes anything that a man wears for his defense, or takes into his hands, or uses in wrath to cast at or strike another. What is more, the Second Amendment, as a matter of plain text, covers, quote, all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. Under this, binding interpretation of the Second Amendment, a firearm equipped with a suppressor is an arm, and a suppressed firearm is the correct object of analysis. California banned suppressors only because of their operation with firearms. Indeed, outside of that operation, they have no utility. Thus, by banning suppressors, listen carefully, folks, by banning suppressors, California really is banning suppressed firearms. Exactly right. That's been my point for quite some time. If you ban magazines, if you ban suppressors, you are banning an entire category of firearms, right? If you ban magazines that shoot more than 10 rounds or can fire more than 10 rounds, you're banning all firearms capable of firing more than 10 rounds without manually reloading. Likewise, if you ban suppressors, what have you done? You've banned an entire category of firearms capable of firing suppressed rounds. It is a firearms ban in violation of the firearms ban rule in the U.S. Supreme Court's 2008 decision in District of Columbia versus Heller. But beyond that, they quote a part of Bruin, but not even the best part, in my opinion. I would have added a different quote, and I would have said that under Bruin, a suppressor is, quote, an instrument that facilitates armed self-defense. That's what Bruin says. An instrument that facilitates armed self-defense is an arm. And suppressors do exactly that. That is quite clear. Beyond that, beyond all of that, if you look at what the Supreme Court said in Rahimi, they specifically said that, guess what? The plain text of the Second Amendment protects all arms-bearing conduct. Not just the arms, but arms-bearing conduct. Check it out. In Heller, our inquiry into the scope of the right began with the constitutional text and history. In Bruin, we directed courts to examine our historical tradition of firearms regulation to help delineate the contours of the right. We explained that if a challenged regulation fits within that tradition, it is lawful under the Second Amendment. Listen carefully, folks. Listen carefully. We, the Supreme Court, we also clarified when the government regulates arms-bearing conduct, as when the government regulates other constitutional rights, it bears the burden to justify its regulation. Fantastic, folks. You see what I just did there? See what's there? The U.S. Supreme Court in Rahimi is talking about if you regulate or ban arms-bearing conduct, the plain text is implicated and the burden shifts to the government to demonstrate and justify their modern-day gun control law. And that is going to be very difficult to do here because once it's established that a suppressor is an arm, or the use of a suppressor is, or at least the regulation of the use of a suppressor is regulating a type of use or a form of arms-bearing conduct, the plain text is implicated and the burden shifts to the government to justify, in this case, their suppressor ban. When they do that, they're not able to win because there's literally 3 or 4 million or some crazy number like that of suppressors in use by Americans for lawful purposes. And as the oral argument during the oral argument looked, if you looked at the oral argument, California really was not able to point to specific examples of when suppressors are used by criminals to engage in crimes. It's just not there. And also, they had some speculation about sort of the value of banning suppressors, but it was at most that speculation because the criminals are not using suppressors when they engage in their psychopathic behavior. It's simply absurd to think that's the case because there is no evidence of that. And basically, California essentially admitted to that and conceded that point in this oral argument, which I think is going to be very, very favorable to the Second Amendment when this 3-judge panel issues their ruling. I also thought that the Second Amendment attorney made a very good argument in favor of Mr. Sanchez by pointing out that there's a Second Amendment right to train based on the Supreme Court's decision in Heller, and it's very helpful at a minimum to use suppressors for training purposes. Specifically, here's what the Supreme Court had to say in Heller talking about the importance of well-trained Americans in arms. Heller said, quote, "There are many reasons why the militia was thought to be necessary to the security of a free state. When able-bodied men of a nation are trained in arms," hear what I just said, folks, "are trained in arms and organized, they are better able to resist tyranny." That's a fantastic, powerful point made by the Second Amendment lawyer in favor of Mr. Sanchez. In fact, he really had three arguments here. He said that suppressors are helpful for three different components of the Second Amendment. One is that you have a right to train under the Second Amendment. Suppressors help with training. And of course, it helps self-defense by reducing disoriented effect of the firearm blast after you touch off a round to karate kill the bad guy. And of course, it also helps with hunting because, you want to protect hunters' hearing while also allowing them to hear their surrounding environments, whether or not there's prey around or whether or not there are other hunters. It's a safety device in its entirety. And of course, what's very helpful here is that the CDC literally has come out in favor of suppressors. And that is very helpful just to sort of paint a favorable picture of suppressors. All right, folks, so there you have it. I suspect we're either going to win this case 2-1 or lose this case 2-1. I got my fingers crossed and my candles lit that we can win this case in the Ninth Circuit 2-1, and the California ban on suppressors will go bye-bye. Of course, it's the Ninth Circuit, so if we win in the panel, they'll probably en banc it in reverse, but one just doesn't know. All right, folks, so there you have it. Hope you enjoyed today's episode. Make sure you follow me on X at @4boxofdiner. Don't forget to subscribe both to YouTube and to Rumble, and I look forward to talking to you again real soon here at the 4 Boxes Diner.
Orders up. Table 2A.